In this video, I'm going to be talking about common objections you see in a custody case. Objections are used in every case and they help keep bad evidence out and help you keep good evidence in, and it's good to know about in every family law case. So about me, my name's Nathan Vining. I'm a family law attorney in Indiana, and I represent individuals in family law cases throughout the state. By the end of this video, you should know more about what objections you typically see in family law cases. So in Indiana, the rules of evidence are applicable to every child custody proceeding, and there are the rules that determine what evidence comes in and what stays out at trial. There are countless rules and nuances to the rules, and I'm going to go over 4 common ones that you see in every custody case. The first common objection is relevancy. You can object to the relevance of evidence if you think what the witness is saying or the thing they're introducing has nothing to do with the case, or it's not important in determining who should win in court. For example, asking about things in the distant past may not be relevant, or asking scandalous questions that aren't related to the proceeding. Judges have a lot of discretion when ruling in relevancy objections because a lot of things can be seen as relevant in a custody case. The second common objection is hearsay. A person can testify as to what they know to be true, but not what they heard from someone else. If someone tries to testify about what someone told them, then that statement is hearsay and you would be able to object. So for example, you can't tell the court what your kid said, what their teacher told you, or what a friend has told you. For you to get this evidence in, you need to have that person come to court and testify directly. There are several exceptions to this rule, and one of them is the opposing party. You can use out-of-court statements from the opposing party in your case. A third common objection is leading. If the other party poses a question on direct examination that leads the witness to a certain answer, then you can object that the question is leading. These questions suggest the answer of the question in the question. For example, did you see Michael at 3 p.m.? Rather than when did you see Michael? The question indicates the answer, which is 3 p.m. Another example is, was John wearing a white shirt? Rather than saying, what was John wearing? The question has the answer in it that John was wearing a white shirt. Keep in mind, though, that leading questions apply to direct examination, which is you examining your witnesses. If you're examining the other party's witness, you can ask leading questions. The fourth common objection is lack of foundation. A question or response can be objectionable if a person fails to explain the background circumstances that specifies how they know the information they're testifying about or what they're being asked about. So when answering about specific facts, the witness has to set the stage and explain how they know that information. So for example, a person can't testify about the person's home and it being unfit for the child if they haven't been in the home. So they need to set the stage for how they know about the conditions of the person's home. So here are 4 common objections you see in a custody case. If you have more questions or need help preparing for a case, give me a call. I'd be happy to help.